With the clock about to strike 11, let me say to everyone, hello and welcome to this wonderful event. Go back a slide, Steve. We're not done yet. For the recorded people, they need to see that we are here for our fifth annual. I can hardly believe it. Our fifth
Fifth annual.
annual
That's crazy. It's crazy.
Top
We're getting old.
Cases 2024. And I'm super excited about this. For those of you, by the way, who are always eager to know who won last year, we're not going to recap that. All the top cases awards are now listed on the website under About. You just go to the petersankoff.com About and you will see who won in 2020, 2021, and onward. But we are here today for our fifth annual top case as I'm joined by my colleague, as I have been every year, Stephen Penney. Stephen, how do you feel about 2024 coming to a close?
Well, it was a pretty eventful year. I think we've got some pretty exciting cases to recount, some good ones, perhaps some not so good ones. And I'm looking forward to see who the winners are going to be,
Me too.
right?
As you
That's the
know,
most exciting part for me.
yeah, as you know, our participants get to help choose the winners after we make the pitch and who the nominees are. And we are very excited. And by the way, for those of you here today, I have actually prepared a quick poll. I am very curious about this. So please fill in your answers. I'd like to know how you feel about the awards concept. I personally love it, but I'm interested to know how everybody else feels. Not everybody's an awards person, Stephen. Some people just want the analysis. But I'm pleased to see that we're not alone as the votes come in, Stephen. Everybody kind of likes the hardware, so we are very excited. I just want to point out that the winners this year will receive actual certificates. We're trying to blow this up a little bit, and you all seem to like it. So I'm pleased to see that the results, Stephen, our awards are fun. So we're going to keep going with awards. We're going to be recognizing the winners, and we are excited about it, Steve. We have a jam-packed schedule. We better get right into this because there's a lot to talk about from 2024. So the first thing I just want to mention, the CDE management, those people here are slave drivers. We just want to remind you that all of the books are available on special with the coupon code Holiday Cheers 15. That's criminal defenses, legal writing, and animal protection law. So great time to get your Christmas stocking stuffer for the lawyer in your life, Stephen. And I'm pleased to hear it. All right, it's showtime. We've got a very busy day, and I can tell you it's been a busy day for the Supreme Court too. We're gonna mention the award categories here. We now have a little bit different. You might notice we have added one award and taken one award away. After a lot of discussion, Stephen and I felt that the Trenches Award and the Defense Hero Award, they kind of overlapped, wasn't it, Stephen? It was just too hard to
Yeah,
do.
I think so. Yeah, put them together.
But we have added the most unusual decision, which recognizes what I love. And for those of you viewers who watch Cabinet of Curiosities, we're going to give out the Cabinet Award. This is not a voted on award. This is just decided by Stephen and myself. The strangest case of 2024. We will make mention of it later today. The way we're doing this is we are going through the cases in our usual way, and awards will come at the end as we usually do. So, Steve, it's been a crazy week. I've got to start the show by mentioning five cases that were not considered because they were just too late for award season, Stephen. You know how it is, right?
That's right. So we got to consider those. And after we do that, we'll look at in increasing to an increasing degree of importance. The first category, too important to ignore. These cases matter. And then finally, the long wait will be ended, and we'll look at the case of the year nominees. So the too late for consideration. Peter, you want to take us through
Yeah, I'm
these?
going to go through them. There are five cases that have come out within the last 7 days. I'm doing case alerts on all of them. Today's case alert is gorgeous. That would have made this list. It's an important Section 276 case. You'll have to live with a case alert that came out this morning. I mean, Park is a Cabinet of Curiosities case gone wild. It is a fantastic case about recklessness and assault and a dog. It's great. Levesque is a very important case for those of you who are doing bail. It's really an interesting Section 516 bail case. Gagne is a wild mistrial case. I'm not going to lie. This one is really important for those of you who need to run mistrials. It's very, very useful. There will be case alerts on all of these. And of course, we can't forget this morning, Stephen. The Supreme Court wanted to throw us off. I'm not kidding, Steve,
They're
because
messing with us. The timing cannot be coincidental. No way.
they knew. They knew,
Yeah.
Steve. Because it's going to be hard in 2025 to put this in the case of the year. It came out this morning. We're just here to tell you this case would have made the show. I've already looked at it. It's big enough. It would have made the show. Would you agree, Stephen?
Oh, without a doubt.
Yeah. I don't know where it fits, but it would have made the show. But let's get into what we do have. Let's start it off with too important to ignore. Am I leading, Steve, or are you? I can't even remember.
I think I'm leading off here with the first case, which is the King and Wang, an Ontario Court of Appeal decision. Just to take you through it very briefly on the facts, the police received a tip that the accused was trafficking. So they mounted a poll camera. We've seen a number of these cases in recent years outside of his home for 8 straight days, continuous video surveillance. What did the surveillance observe? Well, the front area of the home. So captured the movement of people and vehicles in and out of the home and any activities taking place in front of the home. So what's the issue? Of course, does this invade the homeowners, the accused, reasonable expectation of privacy? If it doesn't, there's no Section 8 breach, no claim for relief under the Charter. So we have a unanimous decision of the Court of Appeal written by Justice Sawson, and he says, well, poll cameras could, in some circumstances, give rise to an REP, depending on the duration, scope, and nature of the surveillance, and perhaps advances in technology, but not in this case, because this was a public space that any police investigator could have physically observed with his or her own naked eyes. And there was no sort of extension of technological surveillance capacity here in terms of the use of sound, close-up cameras, or perhaps most importantly, an even more extensive period of time. So what does this mean going forward? I think you're going to struggle in an ordinary poll camera case to find a Section 8 claim, but if you've got more extensive surveillance using technological enhancement, systematic surveillance over a very extended period of time, then you might have a case to make. Now, what is most important about this case? Is this, in fact, Canada's greatest Lorne, Justice Lorne Sawson? I say no, because there are other candidates with an even higher profile, including SNL producer Lorne Michaels, and of course, the great Lorne Green.
And just state the obvious, Stephen. That's the first case on poll cameras. I think this is the issue to watch in future, so I'm glad we were able to bring it up. It wouldn't be a case of the year ceremony without a decision from Justice Derrick at the Nova Scotia Court of Appeal. You may recall, savvy watchers may recall, that she was the winner of last year's case of the year with her fabulous Warnell decision. She will not be winning case of the year, but we can't ignore COPE, a very important sentencing decision. So let's talk about the facts. I mean, it's a sentencing circle case, and what makes this case particularly interesting is you have Indigenous accused, glad you, but you also have Indigenous victim, and that is a specific criteria in the criminal code now as an aggravating factor. All the classic factors of Indigenous background are here: violence, early drugs, addiction, crime, intergenerational trauma. So this goes to a sentencing circle through it. Also, I forgot, complex mental health struggles. Everybody at the sentencing circle recommends that a CSO be granted to enable him to secure a treatment facility with long-term secure housing. As it turns out, Stephen, it's not possible because as soon as they realized he had remand credit up to 26 months, he's over the 2-year limit. So he cannot get a CSO. The judge sentences him to 5 years total plus 8 months for the breach. The majority of the Nova Scotia Court of Appeal, written by Justice Derrick, reduces that. And that's why, I'm not going to lie to you, this is a contender for the sentencing case of the year. Justice Derrick sets out so many wonderful quotes here that you'll be using this case for years to come. On mental health, she says the following: judge didn't do enough. And this is an interesting point for defense lawyers. How is imprisonment affecting your client? If you can show that your client is suffering more, that's a factor. Going on, you've got to look at the carceral sentence and the disproportionate impact on this accused. It gets even better, Stephen. I love statements where they say deterrence and denunciation are not the be all and end all. She goes further and says maybe we should question all of this deterrence and denunciation. And what I love here is she's willing to go that extra mile and say maybe this accused wouldn't be where he is if we had had proper treatment at first instance. So I encourage all defense lawyers, use this type of language to get good stuff. Justice Derrick does recognize that it's a problem when you have both Indigenous victim and offender, and that's the real struggle in this case. But she says that's not enough to displace restraint. We've still got to make account for the Indigenous offender. In a concurring opinion, Justice Scanlon says no, that the tension is too big here. Ultimately, Justice Scanlon says we can't forget the intimate Indigenous partner who suffers. And these are interesting questions, Stephen. I do think that where you have both Indigenous victim and accused, it's going to get to these types of struggles. But for what it's worth, I like Justice Derrick's approach. As always, she goes the extra mile. I highly recommend you review this case when you've got an Indigenous offender.
All right, I'm up next to
Uh-oh.
talk about the infamous decision of our own Court of Appeal here in Alberta, in Barton. And why do we see an image of Charles Barkley here? Well, my favorite Charles Barkley saying, and there are many, is this one. It's terrible, Peter. This might be the single worst decision I've ever read. Might be. I'd have to think about that a little further. But why do I hate this so much? Well, let's go through the facts as briefly as we can. There's a long procedural history here. We'll cut to the chase. Barton's hand, it's basically not disputed, causes a large tail in a sex worker's vagina. She dies. We have proceedings that end up at the Supreme Court, a retrial for manslaughter only. And at this retrial, the trial judge instructs the jury on the relaxed standard for vitiating consent. Relaxed compared to Jobadon. Jobadon requires an intention to cause bodily harm and significant bodily harm. He says we can relax this using the common law to recklessness or intention. He also admits a bunch of very inculpatory evidence that had been excluded from the first trial on the basis that the charter was not violated. And so there are three main issues on appeal. First, the duration of the investigative detention that he was subjected to, the seizure of his bag by the police, which contained the computer containing incriminating information, and then lastly, the standard for vitiating consent, where you have sexual assault rather than assault simpliciter. So let's start with Section 9. What do we have? Well, he's investigatively detained at 8:30 in the morning, advised his right to counsel, and he declines. He's recautioned, then he's interviewed all the way until 11:27, and then again until 1:54 in the afternoon. And the trial judge finds that the detention wasn't arbitrary until 11:27. So as a result, he upheld a 3-hour investigative detention. And the Court of Appeal said, this is not a problem. This is a perfectly legitimate and lawful investigative detention, to which I say, as John McEnroe famously put it, you cannot be serious. A 3-hour investigative detention. Why? Well, the justification is the police, in most cases, know that a crime has been committed. I would say they only have to have a reasonable suspicion, but nevertheless, this case is different because the police had to determine what happened. They didn't even know that a crime had been committed. So they had to investigate for 3 hours, including an interrogation of, or at least questioning of the suspect. So the translation, as I see it, is that the less the police know about what happened, the less grounds they have to detain someone, the longer they get to detain them. This is crazy. Like, this is the ancillary powers doctrine run amok. Rather than hewing to the constant refrain that investigative detention has to be brief to distinguish it from arrest, the Alberta Court of Appeal goes hog wild on this because they obviously want this guy to be punished. Same thing happens with Section 8 and the bag seizure. When the accused went with the police, he left his bag with a coworker who was taking it to a move site. Without reasonable and probable grounds, the police obtained it on a ruse, false pretenses, and held it for 24 hours to await the results of the autopsy. And the trial judge said this is an investigative seizure, which I've never heard of before. I've been studying constitutional criminal procedure for a long time. This is a brand new idea to me. And guess what? It's justified by Once again, the ancillary powers doctrine. So the Court of Appeal once again says, not a problem with this. You don't need reasonable and probable grounds or even reasonable suspicion, nor do you even need exigent circumstances. Where does this come from? This is crazy. But once again, Court of Appeal, not a problem. And lastly, on the question of vitiating consent. As mentioned, other courts have applied Jobadon to sexual assault, requiring an intention to cause bodily harm to vitiate an ostensible consent. We know the trial judge expanded this to include recklessness, but the Court of Appeal goes even further to include objective foreseeability. So we de facto have a new definition of sexual assault, at least in some cases. Intention to apply force, sure. Complainant's consent to exactly that level of force, not a problem. We've got harm, anything more serious than a minor cut or bruise that isn't going to heal within a couple of days. As long as we can establish that, we can prove sexual assault. And as long as the harm is objectively foreseeable, once again, we've got a sexual assault, someone's guilty. No mention of the mens rea, not even a marked departure with respect to the cause of bodily harm. Still, we can convict someone of sexual assault that was consented to in any meaningful definition of the term. What could possibly go wrong with that?
Well, Stephen, as the losing counsel in that case, I'm contractually forbidden from commenting. So I can't say if I enjoyed that presentation at all. I blame myself. Obviously, I didn't do a good enough job litigating in that case. What are you going to do? Let's move on. Farugi, this is not a groundbreaking decision, but it's an important sentencing decision nonetheless, and it's one of the more useful. I mean, I like this decision a lot, though it sort of shows how far you have to go to get a conditional sentence these days for a sexual offense. Let me be clear. This is a situation involving prostitution. The accused is 19. The undercover officer tells him through this, the solicitation online, through a back page, whatever, 14, he says fine. He's wrong, no doubt about that. Let me just say this. Defense counsel in this case goes the extra mile. They do everything you want in a sentencing case. First, they challenge the 6-month mandatory minimum. He gets 7 months. The first thing they do is get bail. He wants bail because then they show all the things that he's doing as this proceeds through the system. He's got a conviction appeal, a sentence appeal. At the time, he couldn't get a CSO. You all remember the dark old days when it was mandatory minimums, etc. You can't get a CSO. But in sentencing, there's a lot of good stuff here from the Court of Appeal. They acknowledge, of course, even though I believe that inchoate offenses they're not victimless, I tend to think they should be of a lower gravity of the offense because there's no actual victims involved, but nonetheless. Here's the great stuff. They go into all the mitigating factors. And if you look at what they are, the keys there, obviously showing a remorse, pro-social lifestyle. Look at the ones: complete lack of risk, proactive participation in treatment, proactive volunteer work. All that happens post-conviction. So it shows what you can get when you go that extra mile. This is a first-time offender. He took accountability. Conditional sentences available, which is great. It's hard to get them. On the mandatory minimum, Justice Arnett strikes it down. The expert opinion, and this has been happening everywhere, this is not the newsworthy part, points out that for this offender, he's a product of poor judgment. And quite frankly, I couldn't agree more. You look at the evidence in this case, and what you have is a guy who has no sexual experience and is trying to get some. Unquestionably morally blameworthy. The officer says she's 14 and he's like, no problem at all. That is a problem. But at the end of the day, separating the accused from the community, like that too, he doesn't pose any risk. Defense counsel here went the extra mile and got the good result. Always a good message to take in one of our cases of the year.
All right, our next short but sweet case is White Hawk. So White Hawk is a challenge for cause case involving two aspects. Firstly, indigeneity, so indigenous accused, but he's also a member of the street gang. And the defense wanted also a detailed questionnaire, not the usual sort of yes or no questions, but, agree, strongly agree, disagree, strongly disagree, that kind of thing, to gain more insight into the potential bias of prospective jurors. The trial judge allows the indigenous question, obviously, not an issue, but only on a yes-no basis, so limited form of questioning. And he refuses altogether questioning about gang membership, analogizing this to a challenge based on the nature of the offense, which the Supreme Court rejected in Find many years ago. But if you look at Chohan, the Supreme Court of Canada, no matter how you slice and dice the competing views and opinions in that decision, clearly was receptive to a much more open-ended, much greater range of characteristics for challenges for cause, not just race. So we have appropriate questions based on these, different kinds of characteristics, as long as they're relevant to the salient aspects of the case. So what aspects of the case are salient? And here you have Justice Kalmakoff at the Saskatchewan court providing some very helpful thoughts on this. So he notes that some of the courts have interpreted Chohan very restrictively and limited salient aspects to immutable personal characteristics, race, ethnicity, gender identity, etc. But that's not consistent with the majority judgments in Chohan. They eschewed this kind of categorical approach and specifically included occupation, referring to Barton and the fact that the sex worker would be something that would be subject to bias and would be a fruitful area for a challenge for cause. So he found in the end that the trial judge erred in finding that this was an allegation of an offense-based bias. And he approved the challenge for cause based on gang membership, recognizing that many members of the community would stereotypically associate someone who's a member of a street gang with criminality. And there'd be nothing wrong, it'd be very salutary and helpful to question prospective jurors on their attitudes and on their ability to set aside any bias they might have to someone who's a member of a street gang. Now, unfortunately, he didn't address the form of the questioning. So we're still left with sort of the mess that resulted out of Chohan in terms of the different judgments, where 4 judges said, no, the questioning should be limited. 4 judges said it should be more probing, and the tie-breaking judge decided not to break the tie. So what can we take from that? I think there's some opening to argue for more open-ended questioning, but time will tell as to whether or not that occurs.
2 points on that, Stephen, very quickly. One is I always forget how much I miss Judge Brown. Just seeing all those Brown pictures, I really miss him. And second of all, I can't believe Whitehawk is not more highly ranked. Tells you about the competition this year. As is the case with this case, this is my secret love case. I love it. I think it's a great case. It's based on Wigmore privilege. You've all heard of Wigmorian privilege. Well, this case is just, it's great. It's a really wonderful case because it is, without question, and I studied this jurisprudence, the best case ever on common law privilege. So if you ever have that type of case, you're going to rely on NS. This is a case that's bad. There's an arson, a really bad arson in this case, but you also have a very mentally distressed offender. This is exactly when you want to have privilege. She makes admissions, but you have to understand that the psychiatrists are trying to assess how dangerous she is to herself and others, and they say that. She signs a waiver that agrees that communications can be given if she presents a future danger. Well, when the cops hear about the statements, they try to use them. So what do the accused do? There's no other way to stop use of this information but the Wigmore privilege. 4 criteria, if you've never heard of it. Were they made in expectation of confidentiality? Is the confidentiality essential? Is the relationship one that society encourages? And finally, it's criteria number 4 that explains why it's so hard to get a common law privilege out. It's really hard in any case, because what happens is you're on one hand, you're saying, do we need to rectify the arson in this case and convict this person? Or do we want to protect the communication? The balance almost always favors admission. That's the problem. But not in this case. The trial judge does a great job, says the first 2 criteria are met. Obviously, it was confidential, and obviously that confidentiality was essential. You need to understand why the person is in the hospital. Everybody has an interest in pursuing free communication. I mean, all of this is great stuff, right? The trial judge was very understanding, excludes the evidence, so the Crown appeals. Of course they do. And what happens? Justice Ruel of the Quebec Court of Appeal writes a thoughtful and understanding judgment, saying again, this is essential stuff. We want to encourage people to speak. Mental health is important, and the relationship, this is the key, Stephen. Failing to protect communications would have a chilling effect on people with similar conditions. Now, I would argue that that's why we should have a class privilege for these sorts of communications so that we're not weighing this every time. I agree. This is important. But at least Justice Ruel goes the extra mile and says maintaining the confidentiality takes precedence. And I love it. I love every word of it. It is essential that people communicate with candor. I love NS. It's a contender for an award. You'll see it a little bit later on. Very useful case when you're trying to exclude communications that are made in this sensitive health environment. It is unfortunate we don't have more cases of this type. We're into the big ones, Stephen. These cases matter. So let's talk about them. The first up is Brunel. I believe you're leading that one, Stephen.
Yeah, Brunel, of course, Supreme Court decision, very important, I think, in opening up the possibility of Section 7 abusive process claims, even where your client has not suffered any other charter violation. So how can that happen? Well, let's look at the facts. There were 30 people arrested during this very large-scale operation in Quebec, and there are breaches of Section 8 and 10B for some of this group, but not all. The main Section 10 breach was the refusal of the police to let anyone access counsel immediately at the scene. And they did this reflexively based on the standard sort of police policy. We don't do this. We've got the facility set up back at the station. We're not going to give you access to a lawyer at the roadside or at the scene of the initial arrest. And they argued together that these were systemic breaches requiring a stay. So coordinated tactical, strategic response by defense counsel to really go for the big prize here, a stay of proceedings for everyone. And the trial judge granted the stay, but the Court of Appeal reversed. And the main questions at the Supreme Court were, number one, what do we do with Section 10B in these types of situations where there's been an invocation of the right, but then there's been a delay in implementing it because the police say, it wouldn't be logistically feasible, and they based that on potentially a blanket policy. And then even more importantly, this issue of whether you have standing to assert an abusive process claim under Section 7 when you're one of the people whose rights were not violated. So that's the truly innovative part of this decision. So let's focus on it first. Normally, to have standing to seek a remedy under Section 24, whether it's a stay of proceedings under 24.1, exclusion of evidence under paragraph 2, you have to allege a breach of one of your own rights, right? But Section 7 protects against abuses of process. Like whether you bring an abusive process claim under the common law or under the charter, it's kind of the same, but it's a protected right under Section 7 in at least some cases. Now, of course, you're only going to get the stay of proceedings in super bad cases, the clearest of cases, but you certainly have standing to assert in any case a violation of your own section right not to be subject to an abusive process. So that's the hinge here. Why is that important? Because even if your own rights under, say, Sections 9, 8, or 10 were not violated, you can still potentially claim an abusive process, therefore a Section 7 violation, and therefore be entitled to a remedy under Section 24, such as a stay of proceedings, even without suffering a particular violation of your own rights. Yes, Peter.
Yeah, I think this is a very big case. I've been saying that since I did a case alert on it early in the year, because to me, the reflexive response of the Crown and many courts in these types of cases is, well, your own personal interests are not affected by this search, by this detention, by whatever, therefore you're completely out of luck. I don't think that's the case anymore. I think Brunel opens the door to something that should have been opened, in my opinion, a long time ago. As you may remember, Stephen, the first law article I ever wrote in my life in 1996 was complaining about Edwards and saying, look, this is too restrictive. We need to have some ability to challenge these things where it's particularly egregious. I think Brunel really follows up on the decision that I think started this. That's actually Justice Moldaver's dissenting opinion in America, where he recognizes that even where you don't have a personal interest, you can raise this in cases where it's serious, where it's an egregious type of violation. In my opinion, the charter only makes sense if we allow third parties to raise these sorts of issues. I mean, would you agree with that, Stephen, in
I
these
do.
types
I
of
do.
cases?
Technically, of course, you can't be a third party because you have to be able to assert a claim of your own Section 7 rights. But effectively, you're a third party to the actual charter violations that occurred
Yes.
from a functional and practical sense. And you're right. I think the idea behind an abusive process is to dissociate the courts from unacceptable conduct or prevent an unfairness. And we know in many other situations that you don't have to necessarily establish personal prejudice or harm in order to force the court to dissociate itself from something terrible that's happened. So I think it's consistent with that line of reasoning, and it's perhaps surprising that it's taken this many decades for
I
the
do
court to
think
sort
it's
of
surprising.
firmly to state that this is a possibility under Section 7. So it's a very good judgment from that perspective. So just to take you through the reasoning very briefly here, you have Justice O'Bonnison saying, an infringement of Section 7 may result solely from the fact that state conduct causes prejudice to the integrity of the justice system, so not necessarily to your client, irrespective of whether the conduct had an impact on the other rights of the person alleging it or on the fairness of the trial. So to have standing, it's not automatic. You're going to have to show that the abusive conduct that didn't necessarily directly implicate your rights nevertheless tainted the police's investigation or operation targeting you or the court proceedings against you. So
Can
there's
I
a kind
ask
of,
a question about that, Steve?
sure, yeah.
I have struggled with that paragraph for quite some time because I've looked at it over and over again. I understand that it tainted the police investigation or operation, but once they say or the court proceedings, like I'm trying to understand what they're getting at because as soon as the Crown brings the case against you, like are they adding a layer, do you think, or are they just like
I
because
think
to
it's
me
a
that's
it's
met
a
every
layer, but it's
case.
a fairly, it's a fairly thin layer, right? It's not going to be very difficult to show in the vast majority of cases, or at least in a high proportion of cases, that
That's
there's
what I thought.
some, substantial link between the misconduct and the investigation that you were a part of, or the proceedings that you're a part of. You're going to have to come up with some fairly unusual circumstances where the connection between those two things would be too remote or attenuated to be able to say that there was taint. So I don't think this is a very significant hurdle for defense counsel in showing, especially in this type of scenario where you've got complex investigation involving multiple targets and accused, and it's all part of the same series of investigative steps or transaction. And it happens that your client did not suffer these direct charter violations. Nevertheless, there were systematic breaches constituting an abusive process, at least arguably. You'll have standing to make that claim and be included in the stay if it's granted.
Can I
And
just
here,
remind everybody out there, of course, that a stay is not the only remedy for an abusive process. Like you do want to argue that exclusion should occur. The only point I'll make is the same one Justice Moldaver made in America, that just because exclusion would happen in the other case doesn't mean that exclusion will happen in your case because it's really got to reach that higher level of abuse, right? And I do think that the court should be a little bit more reticent to exclude when you're arguing it. I hate to say it, Steve, as a third party claim, because I know that's not right. But when you're arguing that way, I do think the court should be somewhat more reticent. But at the same time, abusive conduct is abusive conduct. I've never liked the idea that simply because your privacy rights or whatever rights weren't particularly targeted, that there should be no remedy.
that's right. And, Section 24(2) especially, but many 24(1) remedies, they're not designed to be compensatory. This is not an instance of corrective justice,
Yep.
right? This is, an attempt by the courts to disassociate themselves from unacceptable police or state misconduct. And so the fact that it's a windfall for your client from some perspective is really neither here nor there, right? And you're going to have to convince judges that that's not what a stay is designed to do. And the fact that you're, in some senses, your client may be getting a windfall is just not relevant to the equation here. So in
Great.
this particular case, the court readily found that the misconduct took place in the course of a singular investigation directly targeting all of the appellants and served to gather evidence to prove their guilt. And so even those in the class that did not suffer the charter violations were eligible to make that application and receive that stay. So let's move on to the second major issue here, which is the right to counsel at the roadside, which I'm sure many of you know has vexed and been vexing the courts for some years now, right? Under what circumstances are police entitled, or sorry, required to provide counsel at the roadside or at the scene of the detention or arrest? Well, the trial judge said systematic denial violated 10B, and that while detainees are not entitled, or sorry, the police are not required to permit the accused to use a seized phone or to provide their own phones, the trial judge, rather interestingly, suggested that police should have on hand dedicated phones to lend to individuals for this purpose in the absence of, imminent safety concerns or other concerns that would prevent the confidential consultation with counsel. But the Supreme Court of Canada rejects this idea of having sort of dedicated phones and instead goes back to this very ambiguous case-by-case analysis. Now, that being said, there is a burden on the Crown to prove the reasonableness of any delay in facilitating and implementing the right to counsel where it's been invoked. So how do we negotiate this? Well, we first learned how to do this, 10 years ago in Taylor, where you had the police refusing to provide immediate access to counsel, and they just stuck around until they got a blood sample, and they didn't even consider the possibility that this guy who hadn't been seriously injured, who just started sitting there under observation in the emergency ward, could have been potentially provided with private confidential access to counsel in a room in the hospital. May or may not have been feasible on the facts of that case, but the failure to even consider that possibility, even consider implementing immediately the right to counsel, was found to be a 10B breach in Taylor. So what happens with this principle in Brunel? Well, it's kind of hard to figure out. This is the part of the decision I find very perplexing, and it's kind of a half step backwards in the development of the law in terms of clarity and principle. So what does Justice O'Bonnison say? She says, as a general rule, police may not assume in advance that it will be impractical for them to facilitate access to counsel. Okay, that's consistent with Taylor. On the contrary, they must be mindful of the particular circumstances, et cetera. Okay, so far we're on all fours with Taylor. But then she goes on to say, the fact that the police officer assumes in advance that it will be reasonable to delay without regard to the circumstances of the detention will not in itself entail an infringement of this right. What the heck? Well, that seems to me flatly inconsistent with Taylor, or my understanding of Taylor. So then what do you do? Well, the central question remains whether the delay was reasonable in the circumstances. Question of fact to be decided, yada, 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 in the totality of the circumstances. So unfortunately, I think this aspect of Brunel, in contrast to the Section 7 abuse of process issue and the standing issue, just adds a further layer of fogginess and confusion to the law, and it remains to be seen how the lower courts will implement that in light of the previous ruling in Taylor. Do you have any thoughts on that, Peter?
I don't understand why the Supreme Court is so reluctant to set clearer guidelines. I would use presumptions much more than they do. I don't understand why you just don't presume that if the accused doesn't get access at the roadside, that it's an unconstitutional breach, and let the police defend it on a case by case. Like, to me, that should be the default. I don't like this idea of just like, oh, it's up to them, and we'll consider it in each case. Because what you're doing, and amongst other things, is you're encouraging lengthy voir dires where we try to tease out why the police were doing X, Y, and Z. I think that stuff should be minimized, and I think one way to minimize it is by having default presumptions. Just a thought. All right, I got one that the defense bar does not like, and I'm just going to preface it by saying I don't think it's as bad as the defense bar does, but I can understand what the concern is. Crux a big one, let's not lie. Trial judge makes assumptions about why an accused is not believable, and everybody goes, oh, common sense assumptions are problematic. There has been a lot of case law saying that from every court: Saskatchewan Court of Appeal, Ontario Court of Appeal, British Columbia Court of Appeal. Trial judges can't rely on assumptions, just like myths and stereotypes. They can't rely on common sense assumptions that don't make any sense. Well, apparently they were wrong. Let me have my brief interlude here. I want to explain to everybody that myths and stereotypes have two types of problems. When the other side calls out myths and stereotypes, the first problem is, can you question on things that engage a myth or stereotype. The second is reasoning. Can judges rely on stereotypes or common sense assumptions to reach conclusions? Crook is not universally bad. Crook deals with both these questions, and I would suggest it's good on the first and not so good on the second. That's my take, but let's go through it and sort of see what we got. Yeah, good on the first, not so good on the second. All right, what is the issue in Crook? Justice Martin comes out and says, look, we can't have a rule against common sense assumptions because it enlarges the well established prohibition against myths and stereotypes, which is a relatively narrow area of law. Now, to me, Stephen, what she's actually saying here, and the reason why the defense bar gets so upset about it is because it creates a goose and gander situation. What's good for the goose is not as good for the gander. So the rule against common sense assumptions should not be recognized. The rule is not analogous to the law protecting from myths and stereotypes. Steve, what was your take on this case? I've got my own view and I've expressed it loudly and will do so again. But what was your take about the distinction that she was drawing here?
Well, I mean, I hate to think of binaries in this area of the
Me
law.
too.
To me, it's a judgment call and it's a question of where you put this on the continuum in terms of what is the purpose of the questioning? What's the relevance? Is the relevance derived from the twin myths? Right? That's clear. And similarly, when you've got the judge deliberating or instructing the jury, the question is, all right, what is the purpose of this evidence? How probative is it? And probity can, in my opinion, rely on assumptions and inferences based on logic, human experience, common sense, and whatnot. The law of evidence has been consistent on that for centuries. And how could it not be? It's human nature. Now, at some point, right, the reasoning process may cross a line where we're reflexively, unthinkingly connecting the general pattern of human behavior to the specific facts of what happened in this case and drawing inferences based on an assumption that because this is generally true, it must have been true in this case. We all know that criminal cases often involve very unusual patterns of human behavior that don't conform to stereotypes and generalities. But the idea that you can't use your common sense to help you evaluate the evidence and the actual facts of this case strikes me as being absurd.
Yeah, it's really problematic. I'm as a professor, not a defense lawyer, I look at this case and what I'm a little bit concerned about is this distinction that's drawn because I don't think the distinction actually exists. And what I said in my case alert on this is this, like what I tried to say is, you know, I don't really see these two things as being different. To me, the idea that you can't reason based on a myth or a stereotype honestly, Stephen, if a judge wrote in a judgment that I don't believe that the accused did this because somebody bewitched the accused and used a witch power to take over their mind, I would have a problem with that too, because literally it is the application of a myth to a particular fact situation. But to me, the problem with myths and stereotypes is that these have generated their own sort of impetus in the jurisprudence. And what bothers me is you get a situation where, well, it's a myth that you need to have injury if you're a sexual assault victim. I agree. That is a myth, but it doesn't really tell us very much about whether or not the absence of injury on these facts tells us anything about the case. Because in some cases, you would expect an injury just because of the nature of the force that's being alleged. So I would have been a lot happier on this if the court had just come along and said, well, we're putting all of this in a bit of a corner, and it's really got to take a situation where the reasoning is so out of bounds that it uses reasoning that we cannot condone. But they don't do that. They sort of set two different standards, and I think that is what has bothered the defense bar so much, and understandably so. So, like, that's what I was upset about, right? Is just like, I'm not a big fan of these differential standards unless, as you go forward, like, I think the court had to do one or two things, like cut back on myths and stereotypes and just say these are general cautions, or allow everything to be considered. I'm not a big fan of the latter. I think that's too messy. So at the end of the day, when I look at Kruk, I don't think it's as disastrous as the defense bar thinks, because I don't think it really should be applied very strictly. Though what I worry about is that it might be. Now, this is the good stuff in Kruk. Paragraphs 64 and 65 makes clear that if the Crown is objecting to what you're doing on myths and stereotypes, you got to say something because it is not as broad. I mean, you must have liked that part of it at least, Steve.
Yeah, no, I think that was a much needed corrective to the way that some courts were applying, Goldfinch and other cases.
I agree. And the next paragraph's even better. It doesn't refer especially to myths and stereotypes. Just flip forward, Steve, and you'll see that this is fantastic. I would use this anytime you're in a case when the Crown starts objecting to your questioning and says, well, you're advancing a myth and a stereotype. No, we're not. We're asking questions about this particular complainant. The fact that it touches on a myth and stereotype does not necessarily mean that inferences that can be drawn from that evidence will be prejudicial. I think, quite honestly, to me, this is one of the better cases of the year just for that point. Though I understand the other stuff is more alarming. This case, I'm going to tell you, is up for Raspberry of the Year, worst case. And I'm going to tell you, I would not be voting for Kruk myself because I don't think it falls into that category. But I got so much feedback on Kruk being bad that I have to include it, Steve. We have to respect the audience in this case.
It is a democratic process.
It is a democratic process.
Democratic, Peter. Nothing if not democratic. All right, let's move on to our next case. And that's Costanzo-Peterson, another Quebec Court of Appeal decision. And I think we've mentioned this in prior years, but even if you're not fluently bilingual, I mean, it's really important to pay attention to the Quebec Court of Appeal. It's a great court, a high volume of important decisions. Google Translate works, 90-95% for what you need it for. And, I just highly recommend the Quebec jurisprudence these days. I think you agree with that, Peter.
Always, yeah.
All right, so let's look at this case. What happens? It's a complex cyber crimes and firearms case. Investigation begins way back in 2017. You don't have an arrest and first appearance until January 2020. The next appearance is postponed. You can probably guess why, because of COVID, to June of that year. Everyone agrees that we got to deduct those first the 3 months where the courts are closed due to the pandemic. But then further developments. There are major problems with disclosure and undertakings. The Crown ends up withdrawing the information in September and then relays everything with both the old charges and some new charges. So we're now at 7 months and the defense hasn't even elected the mode of trial yet. We finally get to an election in January of 2021. We're already halfway to the 18-month ceiling. And the trial date is set for July 2022. Trial judge, not surprisingly, issues a stay for unreasonable delay under 11B, and Jordan, the Crown appeals. So a number of important issues here, I think. The first is, when does the clock start when the Crown lays a new information, right, as it's entitled to do, absent an abusive process? Well, here there's a clear distinction Justice Vauclair draws between the mere replacement of the old charges, right, which isn't going to restart the clock, for obvious reasons. So the Crown isn't going to be able to buy time by simply laying a new information, restating the very same charges. But if they're genuinely new charges, then yes, for those, the clock will be restarted at the point of the laying of the new information. But this doesn't really matter in this case because we're still way over the 18 months for all the charges. And so this is just sort of something that may be important in other cases. The second important aspect of this case, the impact of elections. So this can get quite intricate here. I'll try to summarize it as well as I can. Keep in mind, at least according to the Quebec Court of Appeal, that the 18-month ceiling for trials in provincial court is not necessarily always going to be tied to the trial court, right? So for example, the 30-month ceiling, let me restart. You might have a situation in rare instances where you get 30 months for a trial that takes place in provincial court following a preliminary inquiry. Now, how can this happen? Well, firstly, and this is a Quebec-only thing as a result of Section 552, judge-alone trials that in other provinces would be held in the Superior Court without a jury are in Quebec held before the Court of Quebec. So that's one exception. More relevant to people practicing outside Quebec is that whenever there's a re-election to provincial court after a prelim, then you're going to get the 30 months, despite the fact that the trial is held in the provincial court.
Which kind of makes
Okay,
perfect
so
sense if you think
makes
about it.
perfect sense,
Yeah.
right? If there's no preliminary inquiry, on the other hand, and you have a re-election to provincial court, then you get the 18 months. But in these situations, Crown consent is generally going to be required. However, a late election by the defense cannot be used to create a trap for the prosecution. So the courts are going to be sort of concerned and keeping their eyes open for any strategic attempts to game the system here and to set a trap for the Crown that was assuming, with good reason, that this was going to be a trial in Superior Court with a 30-month deadline. Wham! Now all of a sudden, we've almost cut that time in half by re-electing to provincial court. Now, that didn't happen here. There was no evidence that the accused artificially created the delay. In fact, the Crown created its own problems, the aforementioned disclosure issues, coupled with the laying of the new information. And to top it all off, the Crown had consented to the election to provincial court. So it had no cause for complaint. We were way over the guidelines, and therefore the stay was upheld.
Can I ask one question, Steve, before we get to the
Sure.
impact? I mean, I'm always interested. What I'm hearing from defense lawyers is this idea of delaying the election because of insufficient disclosure. Like, I think Justice Vauclair expresses some concern about that idea as well. Like, he doesn't get to the disclosure point itself, but definitely refers to this idea of, the defense has an obligation too, right? Like the defense has an obligation to make these elections when they can, because I just think that 18-30 month disparity is a big one. And where you get sort of delayed along in the early procedure, then the accused suddenly has an incentive to say, well, I want the 18-month period whenever disclosure is taking a while. Like this, what do you take from that? And how do you think that might be adjusted as time goes on?
Yeah, I think we're going to have to wait and see. I mean, it's such a complex series of events that can occur, and every case is going to be different. But I think the guiding principle here is that while the Jordan decision purported to provide a great deal of clarity, saying, okay, there are two categories of cases, it's not quite as simple as I think they anticipated. And so the courts are starting to figure that out and realize that it may not be fair and just to apply the 18 months for
In
all
every case.
provincial court trials. And so you have to be on guard for that as defense counsel. And I would just simply counsel that no attempts should be made to take advantage of this, that in the long run, that's not going to work out for you.
Wait,
In
I just
terms
saw
of,
all these people leave the seminar, Steve. That's
yeah,
one
no
thing.
kidding. I mean, I just don't think that, it's going to work because the courts ultimately are going to come to the position that that's not what the Jordan court had intended, and that they will adjust their parameters accordingly.
I mean, I tend to agree. What I like about Costanzo Peterson, because we're about to talk about the impact of the pandemic, is that Justice Vauclair is not taking shit from either side. He's like, look, where the Crown's doing this shit and it's not advancing the case, that's the Crown's problem. I like the judges who do that. I like the judges who look at it. What bothers me about delay these days is that sometimes the judges see it as their job to move it along and do all this rather than the Crown's, and they start allocating delay periods in really weird ways. My view is like it's sort of on the burden of who's trying to screw around most. In this case, it was the Crown.
It was indeed the Crown. And even if we look at the impact of the pandemic in this case, it's not controversial that this is an exceptional circumstance. But the problem here is that the Crown is going to be incentivized to say exceptional circumstance, exceptional circumstance. This took place during COVID, therefore we got to extend by many, many months. And that's not necessarily going to be accepted by the courts. I think it's a really good decision on this point. Right? It is an exceptional circumstance, but as Justice Vauclair indicates, the effect of the pandemic is going to vary from case to case, and there's no presumptive time limit, right? So some courts have suggested that maybe we should, for the sake of clarity and predictability, have a presumptive sort of time extension, and then we can maybe deviate from that on a case-by-case basis. But he says, no, the cases are too variable to do that. So instead, we have to look at the circumstances of our case and say, you know what? If the parties weren't ready to proceed, if this case wasn't moving forward, then the fact that all of that took place during the pandemic, even while the courts may have been closed, may not be important. In fact, the effect of the pandemic may even be zero, because in this case, there was no evidence that during that 3 month period when the courts were closed, that anything was happening, right? The Crown wasn't ready until 11 months after the courts reopened. And all the disputes about the disclosure and the undertaking and the relaying of the information took place in the fall of 2021 and into 2022. Or sorry, a fall of 2020 and into 2021. And so the courts were reopened by then and things were proceeding, and the Crown could not use the COVID delay to help its case. The
I
last
love that. I
aspect,
love that line. It'll come up later
yeah,
on, I think.
yeah. So the last aspect of this, which I think is again very helpful for the defense, and I think you probably agree, Peter, are Justice Vauclair's comments about case complexity. Because once again, this is going to be a reflexive strategy by the Crown, understandable from their perspective. You know what? It's just not realistic in our case to apply the 18-month or the 30-month, because this case was just so complex. You know, multiple charges, multiple accused, massive volumes of evidence. And Justice Vauclair says, you know what? There are a lot of complex cases these days. There are a lot of cases with high volumes of disclosure. And so that's not going to be sufficient on its own to qualify for an extraordinarily complex case and therefore allow the Crown more time. The analysis is going to be different, he suggests, depending on whether you've got a lengthy investigation prior to the laying of charges, where the assumption is, well, the Crown should be able to manage this from this point forward and come within the presumptive ceiling, as compared to a sudden arrest, which now requires additional investigative steps, all kinds of issues relating to disclosure on an ongoing basis. And once you couple that with voluminous disclosure and all the other aspects of complex cases, now you're sort of in the ballpark where the presumptive time limits perhaps should be extended. But in this case, once again, the Crown hadn't taken any reasonable steps to manage the complexity, and there was complexity, no doubt. They hadn't taken any reasonable steps to manage that complexity, to demonstrate not only that this was a complex case intrinsically, but they had proactively attempted to manage that complexity and stay within the 18-month ceiling. Peter, do you have anything you'd like to
Yeah,
add
just that
in
it's a
terms of this
great case.
decision?
I think it's a stopping point for any case in which the Crown's arguing complexity. Like Justice Vauclair really cuts through the noise of it here, and I think that's an extremely useful thing. Hey boy, it's 276. We know this can't be good, Stephen. TWW, this is my chance to vent and just say, look. Section 276, I actually think this was enacted with some pretty good intentions. I think we were, make it harder for the defense to question the complainant on the past sexual history. And at the end of the day, it's, we have to remember that we have this bar and it's a big bar. And it really doesn't square up with Canadian evidence law, which generally admits relevant evidence. Now, I'm going to tell you, Steve, I've always wondered about Section 276, and I remember the big case of the day, way back before Goldfinch and everything, was Darragh. And Darragh said that Section 276 is constitutional. So what I thought about it is that when I heard that it was constitutional, I thought Darragh was dangerous because I think the 276 as drafted has too many things going on with it. And I was
Sorry,
worried.
I've got a question, Peter. I just can't refrain from interrupting here.
Sure.
Who is that handsome guy in that photo? I don't understand. Like, is it just some
Steve, I remind everybody
random
that
stock
like
photo?
back in 2000, I had hair like you have hair now. And like, I remind everybody that like my life has deteriorated. I've measured it. It's deteriorated by 27% because that's how much hair gives you joy in your life. So I'm just not the same person I was, Stephen. But back then, I thought Darragh was a really dangerous decision because I thought it was limiting too much cross-examination. Now, Stephen, I'm like, can we go back to Darragh? Like, you read Darragh today, and I'm telling you, go read it if you have a 276 case, because it looks nothing like Goldfinch and TWW, which are, really restrictive cases. Goldfinch was the problem. TWW doesn't remake the wheel. It just enhances the problems that Goldfinch created. I am going to do a case by case analysis here. Here's
I love
what
this. This is great. This is
TWW
great.
says, because To me, let me tell you that the biggest difference between TWW and Darich is the tone. TWW uses words for the admissibility of evidence that I think are inappropriate in this case. And my authority for that is Darich, the only case that has considered, Stephen, whether or not this regime is constitutional. In TWW, it's a rigorous statutory regime. Well, in Darich, it's like it's designed to exclude, look at these words, Stephen, irrelevant evidence and evidence that is more prejudicial to the administration of justice. But we have to remember the accused's right to a fair trial is a fundamental concern. I defy you, Stephen, to find that language in Goldfinch or TWW. It keeps going. The statutory regime requires trial judges to ensure that evidence that is misleading, irrelevant, or substantially more prejudicial than probative is excluding. Well, like, I have a bugaboo right there, Stephen. Like, irrelevant? Sure. Substantially more prejudicial than probative? Sure, that's in the language of the statute. What does misleading mean? Like, I'm like, what is misleading evidence? Because misleading evidence is prejudice, right? So, like,
Don't you remember that Wigmore, Moore, and McCormick, and all the great evidence scholars, they devoted entire chapters and volumes to the concept of misleading evidence and why it should be excluded from criminal trials. I can't believe you haven't recalled
Absolutely.
that.
I'm obviously mistaken. Misleading evidence. Of course, lots of evidence can be misleading. Look at what they say in Darich. Do you see those words, Stephen? Trifling relevance. That I used to use that language, but you can't anymore because TWW and Goldfinch are killing it. Trifling relevance. Well, it gets better. I don't, in order to be potentially admissible, the relevance must go beyond a general ability to undermine the complainant's credibility. Like, why is it so bad to undermine the complainant's credibility? Justice Gontier, by the way, rose from, his resting place, RIP Justice Gontier, to say, like, I don't know what that is. There's no parallel to Darich. Like, it just doesn't make any sense. And it gets worse. Read this. I if any of you have ever studied the privilege law and the innocence is at stake exception, that's what this looks like. You have to respond to a specific issue that could not be addressed or resolved in the absence of that evidence. Like, Stephen, what happened to trifling relevance? Now it's like, you must respond to this and read that. Too broad an approach would cast open the doors of admissibility. It's specifically specific and essential to the interests of justice. Like, this is craziness. And if you read Darich, it doesn't say that. Look at this. The accused, I already quoted that, okay? It goes on. Look at this quote. The right to full answer in defense is not engaged where you seek information that will only serve to distort the truth-seeking purpose. That is different, Stephen, from this evidence must be essential to your case, and you could not raise it in the absence of this. Try finding that in TWW. It is incredible what has happened here. Goldfinch started it. TWW continues it. Justice Moldaver, who, if you have watched me at any time, you know that I'm not always the biggest fan. He wrote JJ, but he is dead on in Goldfinch. He writes a concurring opinion, and look what he writes. Bears only marginally on it. Outweigh the tenuous connection. Try comparing that to Goldfinch, and now you will understand why in Goldfinch and TWW, this idea of essential to the interests and all of that is really hampering your ability to admit evidence. And what's most irritating about it, Stephen, is that type of language is nowhere in the statute. It is an invention by the Supreme Court of Canada, and it is used regularly by Crown attorneys who revel in saying how hard it is to get this evidence in. What's your take on all those things, Stephen?
Well, I'd much prefer to disagree with you, but I'm afraid I can't because I think we have created a recipe for wrongful convictions. The pendulum has swung just way too far. What was, I think, a well-intentioned piece of legislation has been interpreted in a manner that simply, deviates too far from the fundamental principles of evidence that have been developed over many decades and centuries that are designed to ensure full answer and defense, fairness, and prevent wrongful convictions, while at the same time, maximizing our ability to search for truth and demand accountability from people who've committed serious offenses. So I think there will be a readjustment. We're going to talk about a case coming up where there's starting to be some pushback against this, but I don't anticipate that it's going to be anytime soon, given the current composition of the court and the current sort of political dynamics in this country. But I hope it comes sooner rather than later. I hope I'm wrong, because I think it's terrible.
Me too. I think the mechanism and the way in which it's described is just destined to cause problems. I mean, they're just, even though the language of the statute says the prejudice has to substantially outweigh the probative value, if you keep creating limiters around that, you're just going to exclude a lot of useful evidence because, well, it only affects a general ability, or it's not.
It's ironic because
it's
I
not
think
essential.
maybe I'm naive. It's ironic because maybe I'm naive, but I think relatively speaking, the average juror and the average judge is more sensitive to the irrelevance
I
of
agree.
sexual history evidence than ever before in our history.
Yep.
Yet we have the most restrictive scheme now. Like maybe this would have been more
agree.
useful in 1975.
I agree
Times have
entirely.
changed.
The calibration is completely out of whack. And
Completely out of
what
whack.
Darich says is, you know what Darich really stands for, Stephen? If the evidence is relevant, it's usually going to come in, despite all that other stuff. That's what Darich says, but try finding that in TWW. It is a problematic case.
Yeah, and I think the other
we've been
point to
asked
make
whether
is
it
that
can invite a new constitutional challenge. Go check out my seminar on injustices that need to be fixed. I have section 276 in there.
and I think the courts have effectively rewritten that statute in an impermissible manner. So that's another issue. All right, Peter, we're at the big ones. 4 cases that we think change the landscape and constitute our list for the cases of the year. And I'm going to start us off with Bajkovic. Many of you will be familiar. What happened in Bajkovic? Guy made some online liquor purchases using a fraudulent credit card, and the sales were managed by a third-party merchant. That merchant voluntarily turned over the IP addresses after these transactions were identified by the retailer. They didn't know, the IP address, so they had to go to the third-party service provider to get those IP addresses, and they were voluntarily turned over to the police. The police then used the IP address to get a Spencer warrant, i.e. a production order from the ISP, so they could tie this to the subscriber and then narrow it down to the individual and arrest them. So what happens to the Supreme Court of Canada? Once again, this is a reasonable expectation of privacy case, and we get a split decision. The rumors, the scuttlebutt is that we may have had a very different outcome in Bajkovic had a certain, evening in a Scottsdale, Arizona bar not occurred a couple of years ago. Some of you, many of you probably know what I'm referring to. But in any case, whether or not that rumor is true, we have a narrow decision where the majority, in a decision written by Justice Karakatsanis, says IP addresses are protected with a reasonable expectation of privacy in these circumstances. Why? Because it links online activity to a particular location. It can be correlated then with other online activity associated with that address that's available to the state. And that can set the state on a trail that will ultimately lead to the identity of someone engaged in activities online that may be of a highly private or intimate nature, and they can do all of that without a warrant. So it sounds pretty reasonable, right? And there also is this affiliated concern about third parties providing even more information about the address and the collection of data that they have access to. And so what do we have to do in analyzing this? She says we have to focus on the information that is potentially going to be revealed by access to the IP address, right? These are the first digital breadcrumbs on the user's cybernetic trail. Now, I know we don't have a category for this, Peter, but I'm curious to hear your thoughts. This is some of the silliest language that I've heard from the Supreme Court of Canada in a long time. Agree or disagree with the majority on this point? Digital breadcrumbs, cybernetic trail. Like, oh, is this a 1989 sci-fi novel? Come on. Like, who wrote this?
I don't agree at all, Stephen. I was just using the word cybernetic trail.
Cybernetic trail. Oh my God.
I was on a nice journey.
How can you display your technical naivete about how the internet works? Use the phrase cybernetic trail. That's a great tip-off.
Or digital breadcrumbs.
Either one. Dissenting judgment by Justice Cote. Yeah, I'm sorry to say, my opinion, much more compelling, even though it's not as defense friendly. She says, you know what? The capacity of any technique to obtain information and whether or not that triggers a reasonable expectation of privacy has to be based on the facts of the case. It has to be supported by the evidence. It can't be based on mere conjecture. One of my pet peeves about this case is that all of the empirical foundations for the majority's assertions come from a single defense expert's report, which I don't think was critically examined. There were no opposing viewpoints presented. We're basing far-reaching policy on the basis of a single expert's report in a single case, right? That's not the way the law should be made. Nevertheless, she goes on to say, let's look at what happened in this case. Nothing in the evidence suggests that the police can obtain any private information about an individual with an IP address alone. Sure, maybe the NSA can do it, right? Maybe the FBI can do it. Maybe the CSIS can do it. But can your ordinary police agency do this? No, there's no evidence that they can, or certainly no evidence that they did. Okay, so I've ranted enough. Peter, do you take an opposing view, or are you sympathetic to the majority's position here?
We've talked about this one at length, and I'm in a quandary, Steve, because my general view is that searches, we've had the discussion before about searches, and my view is that police activities that engage the obtaining of information should be searches. And generally speaking, I'm of that view. But this case to me does not make a great deal of sense. I mean, it's technically good for the defense bar, but I am well aware of the fact that trial judges do not like this decision, and that has a way of filtering its way back upstairs. And I could see this decision distinguished because it has a real impact on the ability to undertake these innovations. It's not a small thing.
Yeah. Yeah, and I think the unfortunate thing from the Crown's perspective and from the police's perspective, and I would say from society's perspective, is that this case arose in the context of, online transactions. And the court's like, well, what's the big deal here? It's a bit of credit card fraud. Let's protect privacy as against, potential online fraud. Not that big of a problem. But the implications, especially for child pornography and child exploitation investigations, are profound. So what are those implications? Well, I will give Justice Karakatsanis some credit here, despite my earlier criticisms. She is careful to say that the reasonable expectation of privacy is only going to attach when the police make a request for an IP address from a third party. So I know there aren't many Crowns in this audience, but boy, if I were a Crown, I would be honing in on every single instance where she uses that language. And it is repeated throughout the judgment. So when they do this, it's clear that they're going to need a production order, right? So they're going to need a production order based on reasonable suspicion to get this IP address. So they're going to have some evidence that there's a crime and that this will support proof of that crime. And then once they get that, then of course they'll get their Spencer warrant, which requires reasonable and probable grounds. But come back to that point about the request. Okay, so if that's the case, then the question arises, is Section 8 violated when third parties voluntarily provide IP addresses to police without a request? And we know this happens all the time in the aforementioned child pornography context. The answer is probably no. So you alluded to the fact, Peter, that lower courts don't like Bajkovic, and they're finding ways to distinguish it. And I think those ways are legitimate, both in terms of the underlying policy concerns, and they're legitimate in the terms of applying Bajkovic faithfully. At least there's an argument, a strong argument, that it can be interpreted to permit this kind of sharing of information because it's not done on request. Okay, but there is contrary authority. So you'll see the citations there, all at the very lowest levels of court. Courts are going to have to resolve this. Presumably the Supreme Court eventually will have to resolve this. And it also potentially threatens the constitutionality of the current mandatory child exploitation material reporting law. Because even though it's technically not a request, you have a statutory instrument here, a statutory mechanism that mandates the disclosure from private third parties to the police. So to me, it's hard to distinguish that from a request in terms of the functional distinction between the two. So, I think it's right for a constitutional challenge, but is that challenge going to be upheld? I mean, I don't know. I mean, I would like to think no, but now you're going to have to find a real workaround Bajkovich. And that's where I think things are really going to come to a head if this legislation is challenged in an appropriate case, because I'm not sure, it's consistent with Bajkovich to uphold this law. And I think the courts are going to want to uphold this law.
Well, statutory balancing, Stephen, Parliament's considered it very carefully.
Yeah.
We got to move on to Reimer. Reimer is the most sensible, logical evidence decision of the year that I am just about certain is going to be overturned by the Supreme Court because it's just so gosh darn sensible. It deals with sexual assault and associated charges, much of the usual stuff. Oh, Jack meets Jill online, and what do? They start texting sexualized messages to each other. As it turns out, Steve, I'm new to this, but as it turns out, people like sending sexualized text to each other. Apparently, that's a thing. The question is, what is the relevance of these particular texts? The trial judge says, no, 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 myth, stereotype, irrelevant, offered, blah, blah, blah. These are the things, right? And it's like, what are we supposed to do with that? Trial judge excludes it. They're not relevant. Consent. This is the big one, Stephen, right? This is the big one. You've got this issue, and it's like, well, is this consent must be provided at the time. So therefore, anything that took place before the time is irrelevant, right? You can't admit. So at the end of the day, the proposed uses are just twin myths. Now, to me, and to Justice Pacheco, who writes about this, the trial judge's approach makes no sense, making this a case the defense bar loves. Why? Well, I hate to break it, Steve, because as you and I know, sexual assault now lives in a vortex area where like the laws of evidence warp, and Justice Pacheco decides to just apply straightforward evidence law.
How dare he, Peter? How dare he?
Advanced consent. I'm just going to explain it to the, lay people, if there are any. Advanced consent is a substantive law concept, right? You can't consent in advance. Now, personally, I think that concept is nonsense to begin with, but let's just go with it, shall we, Steve? Let's go with it. Advanced concept, substantively, you cannot consent in advance. The Crown has been arguing with success that because of that, indications of whether you will consent later are irrelevant. That's just crazy, isn't it, Steve?
It's insane. What can I say?
I agree. And Justice Pacheco agrees too. The only problem is Justice Pacheco's view is inconsistent with that of the BC Court of Appeal and several others. He proposes quite straightly that these types of statements are relevant. And therefore, by the way, can I just say one thing before anybody misunderstands? He's not saying they're always admissible. That's not what he's saying. He's just saying you actually have to consider under the balancing test in TWW and actually assess the evidence. And like the Crown was arguing, twin myth, they're out automatically. That cannot be correct. Justice Pacheco goes on to point out that this is a question of fact. Whether or not she had any intention, that's up to the trial judge to understand. This evidence has to be put to the complainant to understand what is going on. It's open to assess and decide that these represent serious expressions of intention. In my mind, sorry, go ahead, Steve.
Correct me if I'm wrong, Peter, but last time I checked, one of the categorical longstanding exceptions to the hearsay rule is present state of mind or present intention, because it is assumed based on logic and human experience that people will act in accordance with their stated intentions. Not always. Certainly not always. But should we at least see that evidence and weigh it?
Steve,
I'm thinking maybe yes.
You're assuming logic and human experience apply in this area. What's funny about this case, keep going through the slides, is that, like, to me, Justice Pacheco's reasoning is so straightforward and obvious. Like, he's also saying it's not about the reason of their sexual nature. It's simply a question of what they say. Does that have bearing on what they will actually do? We've always assumed that to be the case. We assume it in every other area of the law. Think about it, Steve. what is motive evidence? It's like you're assuming that something that has taken place in the past has bearing on the present. I love that line from Justice Pacheco. There are passages that say this. It's not the law. Well, just wait, Justice P. What's my take? It's so sensible that I expect leave to be granted and the decision overruled. Like, I just think that that is going to happen. Until that happens, make use of it. It's the single most definitive ruling that explains why this should be admissible. And it's just so sensible that unfortunately, in the era we live in, I expect it to be overruled. By the way, I've seen the leave application. It is there. It's going forward. But until that actually happens, this decision is very helpful. I urge you to make use of it.
All right, so let's look at another excellent decision from the Ontario Court of Appeal. Pike, by the way, if you're trying to teach your articling students, junior associates, how to write well or to look at an example of a contemporary judicial decision that's just coherent and well structured and straightforward, it's not dumbed down, it's not simplistic, but it's just very, very clear. I can't recommend a better example than this one. Kudos to Justice Tulloch and possibly his clerks who may have helped him with this, but it's just an excellent example of a very, very well written and very well reasoned decision. So what happens in Pike? It's a digital border search case, right? It's the new Canfield, and it's a much better version of Canfield for those of you familiar with that Alberta Court of Appeal decision. So customs officials, under the authority of the Customs Act, search phones and other digital devices of two individuals at the border crossing after they returned to Canada. And they found, I have to say, a heck of a lot of child pornography. So it's quite a disturbing case.
It's a healthy amount of child pornography.
It's a healthy amount of child pornography. But no suspicion is required under the Act for them to conduct these searches. That provision was struck down in Canfield. Leave was denied in that case. So we have a disparity as between the law in Alberta and everywhere else in Canada. And by the way, the federal government decided not to amend the legislation in response to Canfield, hoping that it would have a second kick at the can and win in Pike. Turned out to be a false hope. So the Ontario Court of Appeal follows up and insists on a reasonable suspicion standard for these searches, and I'll follow up on that point as we go along. The Alberta Court of Appeal equivocated on this. I think the Ontario Court was correct to require at a minimum that there be reasonable suspicion for digital device searches at the border. But it admits the evidence, so it's got a pretty loosey-goosey approach to Section 24.2, as we'll discover. So kind of a win for the defense on the merits of the Section 8 claim, but not so helpful on 24.2. And, again, not so helpful, increases the sentence of one of the individuals convicted at trial on the basis of Friesen principles. All right, so let's start with Section 8. Very briefly here, the Customs Act establishes that all electronic files are goods. So this had been contested by the accused on appeal, but he finds in a manner consistent with other courts that have dealt with this, that this search power only requires good faith application. No reasonable suspicion is required. It's not constrained by any kind of individual's suspicion, right? So you could just use it whenever you want to search anybody's digital device as long as it's within your statutory mandate to find contraband, including child pornography. Now the question becomes, is this a reasonable law? So this is a facial challenge to the law, right? And here is where I think the case makes its most useful contribution for the broad scope of Section 8 jurisprudence, because the Supreme Court of Canada hasn't done a very good job of this in recent decades in articulating actually how we go about assessing whether a law is reasonable on its face. And so he articulates a multi-pronged approach, which I think is very sensible. We look at the intrusiveness of the law. Obviously, searches of digital devices, even at the border, are highly intrusive. Is this a reliable way of detecting the illegal contraband? Not especially. The evidence at trial indicated that there was a 62% error rate. Every time that someone was searched at customs, there was a more than 6 out of 10 chance that nothing incriminating would be found. So it's not particularly precise. What about oversight mechanisms? Well, there's no threshold and no warrant. So there's really no oversight whatsoever. What's the purpose and nature of the law? Well, yes, there's a diminished expectation of privacy at the border, But there's a weaker interest, he points out, in searching for electronic material compared to physical contraband. And this is, I think, something that has not been recognized fully by the courts, at least not until Canfield and especially Pike. Because let's be honest, is child pornography being brought into Canada physically on people's devices through borders? Yes, of course, it happens. What's the percentage? 1%? 0.1%? 0.001%?
It's such a good part of the judgment. Like
There's
it's
just
my
no
favorite
way
part, probably.
that efforts to find
Yeah.
this kind of contraband at the border will do anything to stem the problem of child pornography and its accessibility online. So that's where I think a critical distinction is drawn between digital material and physical contraband, where the state has a much stronger interest in being able to surveil, oversee, and to conduct searches and seizures potentially without individualized suspicion. And he goes on to say, again, this is a great point. Customs searches aren't purely regulatory. We know that customs officials take on this sort of law enforcement mandate, this criminal law enforcement mandate. These are offenses both under the Customs Act, but more importantly, under the Criminal Code. In fact, there are even cases where there's coordination between ordinary law enforcement agencies and customs, saying, flag this guy. We don't have the grounds to get a warrant. Just search his device when he comes back from the Dominican, he comes back from Cuba, etc. And he also highlights a very important point. When you have these open-ended, almost purely discretionary search powers that are highly intrusive, you increase the risk of discriminatory profiling. For all those
Can I just
reasons.
say one quick word, Stephen, on
Sure.
this? Because I know we're short of time. I just want to say that we're about to start complaining about some of the things he does. And I think this part of the judgment is really a tour de force. First of all, it's well written, but the points that are being made are so sound. But you have to understand that the Crown fought every one of these points the Crown fought. And I think it's really, truly wonderful that you've got these sorts of, refutation of these arguments one by one.
Yeah. Yeah, I agree. And, I'm a little biased because I made many of these same points back in 2016 in an article, which does get
I believe
cited.
you might have got
So
cited.
thank you.
Yes.
Thank you, Justice Tulloch. All right. So once again, just to be brief here, reasonable suspicion is required as a minimum. Parliament can do what it likes, but we're going to insist on reasonable suspicion as being the constitutional minimum. And as I mentioned, the Alberta Court of Appeal have equivocated on that, suggesting there might be some standard, below reasonable suspicion, which I think is a terrible idea. That's the last thing we need is another standard, especially one that goes even lower than reasonable suspicion. So I won't dwell on Section 1 or the remedies issue. It's very interesting. If you have an interesting case where you strike down legislation, Crown seeks a declaration of suspension. You've got constitutional exemptions. All those issues are highlighted. Again, very well analyzed, very well argued, and I highly recommend them to you, but we don't have time to go through them, I don't think, here today.
No, skip through those.
Very briefly on Section 10, nothing really new here. Routine searches and questions do not trigger detention, but a detention will be triggered by searches requiring reasonable suspicion, including digital device searches, or any questioning that contains improper inducements, exerts unfair pressure, involves coercion, etc. Okay? 24.2, pretty standard. The police were given a break because they reasonably relied on the law that had been upheld in Ontario and other jurisdictions for many decades. There's a diminished expectation of privacy at the border. I think that's maybe a little bit dicier. And then he says this is a very serious offense with international implications. As a result, we're going to admit the evidence. He also talks about the sentencing, which I mentioned, child pornography bad, guideline of 5 years at the upper end for mere possession. Yes, you can get a CSO, but it's going to require de facto exceptional circumstances. There are lots of aggravating circumstances just generally that are baked into child pornography, so not good for the defense, but he does strike down the minimum sentence for importing. So we come to the final case, Peter.
We got to get through the final case. I'm just going to say about Pike very briefly on Section 24. I have issues with the 24 analysis. That is set out in my case alert on Pike. I won't repeat them here. The beauty of Larson, Stephen, is that we can let it speak for itself. This is a judgment from a judge of the Saskatchewan Provincial Court who has decided that Section 278.92 and the myriad of applications has run amok. I have reported on this case extensively. I leave the quotes for you about what this case says. This is essentially a problem of delay, but the judge has kind of had enough with all these preemptive applications. And here is some of the beauty that comes out of this trial judge's mouth, Stephen. Let's go through some of these quotations. I mean, it's beautiful stuff, isn't it? 2.5 years after Jordan, Parliament introduced this section. Purportedly as an ameliorative effort. Okay, what next, Justice Ribchuk? While well intentioned, this runs counter to a shift away from a culture of delay. Don't you love further drained, precious, limited judicial resources? It's a mess. I've been sounding the bell on this. It's a mess. This is really complex. And what I like about it, Stephen, is this is the judicial perspective. Obligations to provide reasons. This is taking forever. So the judge kind of sounds off a little bit, does he not?
Well, I mean, just imagine, I don't know this judge, but just imagine as a provincial court judge, how frustrated you have to be, how, angry perhaps you'd have to be to go after the Supreme Court of Canada this vociferously. You can debate about whether, this is proper or not, but
Judicial
boy,
language,
the language
properly
that's used here is
judicial
not, I'm
language.
sure he felt he was restraining himself, but boy, it comes across loud and clear. And I can't say I blame him.
Well, this quote's not even the big one, right? But it's like they've inadvertently produced this. I love this too. I mean, any judge who can use doom scroll in a judgment, I'm on hands. And any of you who have done this, by the way, will know that that's what it's like. It is a difficult process, and this is when the judge really fires shots across the bow, right? This is the big quote. And this will be up for quote of the year in case you're worried. But I mean, yet they have elected to endorse a pretrial process that injects further burdens, all while waxing poetic about the implications of trial delay. I mean, I couldn't say it better myself, Stephen. In fact, I've adopted some of this language in my presentation. Look, this is bad. The judge is upset that he had to stay proceedings, all because of evidentiary pretrial applications. We all know this is a disaster. This judge is letting us hear it, and I think it's beautiful, and I think it's what we needed, Stephen, to bring this presentation to a close and get us on to awards season. Here we are, ladies and gentlemen. This is your chance to be a part of our process. We are going to start. This has been awarded by acclamation. Nevin, if you haven't seen my case alert, you should. We have decided that this is the case where the judge, I'm going to say, loses his mind, Stephen, and decides to, after he's on his own motion, he starts calling witnesses to defend himself. This case is bananas. The Nova Scotia Court of Appeal does a great job of handing it out. I am calling this the Cabinet of Curiosities Award, and we are awarding it to the Nevin decision. Yes, well deserved. Thank you. We are pleased, by the way, Stephen, to hand out the first ever Alan Manson Award to honor the great scholar. You get your chance to vote. I'm going to put it out here. You've heard about these cases. It's your call, ladies and gentlemen. Who should win the Alan Manson Award, the inaugural Alan Manson Award for the best and most important sentencing decision of the year? I honestly have my thoughts about this one. I think they're going to be borne out. It's getting a little closer. Getting a little closer. They're both very good decisions. Stephen, the votes are coming in. I didn't want to impact the votes. Where would you go on this one, Stephen, out of curiosity?
I think I'm not going to go with, I'm guessing the majority is going to be Cope, but I think I would pick Ferrugi.
I personally would go with Cope, and I've got to tell you that for the second year in a row, the Nova Scotia Court of Appeal is not walking away empty-handed. Justice Derrick, once again, is walking home with some hardware, Stephen. Very happy to hear it. Thank you to our voters. Let's move on. Ooh, this is a tough one.
Oh,
We got
yeah.
three.
How many times can I vote?
I've already made my comments about this, but I'm letting the viewers have it. Steve, what is the single worst decision of the year? Who knows, Steven? Maybe I had some influence on this one. I don't know. What is the single worst decision of the year? I know my pick,
I
Steven.
know who
I
I'm
think
rooting
I know
for here,
your
but
pick.
there are no losers here because they're all losers. All these three cases.
Well, but Steve, you and I will feel somewhat vindicated. The answer
Yes.
is Barton. That is viewed as the single worst case
Woo!
of the year. I can't comment. I'm contractually unable to comment on that particular case. I'm just
Well-deserved award.
glad
What
that
can I
Kruk
say?
didn't win it.
Sometimes the award ceremonies do get it right.
Yes, I'm glad Kruk didn't get it. Morris Fish Award is going to be tough. So I'd like you to read these. R versus MJ was not considered in the case of the year, but this quote is just a doozy. Don't you love that? I absolutely love this. This is Justice Brock Jones out of Ontario. It's a phenomenal quote. I mean, look at that. It's just gorgeous. I hope that type of language comes up more often. So that's the Sawyer order quote. We've seen the rest. I mean, Larson, we just read. We don't need to spend time there, all while waxing poetic. I love it. Cope has a biggie here. Not only her sentencing, that's we talked about that. The doubts about incarceration as a deterrent, and finally,
Oops, sorry.
That's Costanzo Peterson. I mean, look at that line. In other words, a case may go through the aftershocks. By the way, Stephen, I did not include, there is a line in Nevin that I'm really sorry we didn't include. It's where Justice says a person is not expecting to have an additional prosecutor in judicial robes. I love that line. I'm really sorry that I didn't include it, but we're going to go with these four, which is the winner of the Morris Fish Award for Best Quote. I have a feeling it's hard to beat, but there's some good votes in there. I mean, it's pretty hard. This is a fight. This is a battle, Steven. Get your votes in
All right.
there.
I'm eagerly anticipating the results here.
Me
I'm on
too. I
pins and
thought this was
needles.
going to be a walkover, but I think that people like that MJ quote as much as I did. And it's very close. Get your votes in. We don't have a winner at this point. It's literally tied. We need some votes. We cannot award this on a tie, Stephen.
No way. We got to break the ties one way or the other.
Well, I'm going to break the tie with my own vote in this. Oh, we have broken the tie. So I will give it Larson wins in a squeaker,
Ooh,
Stephen.
man.
Just
A
beating
squeaker.
MJ, which is a
Yeah.
very, very honorable mention. Okay, let's move on.
Oh,
We did it already. Fresh start. I think there are three, and I think they're all worthy contenders. Which of these is the most innovative decision of the year? Let's see what we've got here. Whoops. Poll result is being shared. I got to stop sharing. Which one did we just do? Fish. Stop sharing. There we go. Fresh start. Boom. Which of these three? I think this is a tough battle, Steve. I can see any of these winning. This to me actually was the toughest battle. Yeah, and not surprisingly, it's getting some votes across the spectrum. Also very tight, as I thought it was going to be. Whitehawk on challenge for cause. Oh, it's is incredibly tight, Stephen. We might have to break the tie. Anybody else out there? By the narrowest of narrow margins, it's Whitehawk, Stephen.
wow.
Whitehawk
Very
is the Fresh
interesting.
Start Award for innovation. I think
Very
they're all
interesting.
worthy recipients in this case. I think that brings us. We have to do case of the year first. Defense hero is still lacking, but I've already decided that they can't win both. So, case of the year and defense hero overlap a little bit. Let us decide who is winning the case of the year, ladies and gentlemen. Which is it? What a battle. The votes are coming in, Stephen, and I predicted this one long before it actually happened.
Yeah, I like to be a contrarian whenever possible, but I think my vote on this one is probably going to be the winner. I
Uh,
just think it's such a great case, and it's from a great judge. and it came out at the right time.
So I'm just going to
And
tell you, it is the winner. It's a runaway winner, and it was also a winner on the pre-voting that we did. There is no doubt, and I knew that Reimer was going to win. I'm just going to say, to me, it's actually Pike. I actually think Pike is the more interesting decision and more impactful overall. Not that I disagree with Reimer. I think it's amazing. I'm just like, to me, it's such logical obviousness that it just needs to be the way it is, which leaves us with just one remaining, which is the defense hero. And we're going to hand that out by acclamation because I simply cannot give that to Reimer twice. So I'm going to give that to Larson. We just decided whichever case doesn't win case of the year is probably the best one for this. Stephen, I just, you know how much I enjoy this. And, sorry, I've got that wrong with A, B, C, D, E, but that transfers over to 1, 2, 3, 4, 5. Stephen, let me just say my great admiration and thank you so much for such a wonderful presentation. I really hope that all of you out there enjoyed it as much as we do. We know it's gone a little long, but thank you so much for sticking it out. And I will simply say, to everyone out there, thank you for being part of our case of the year. Look forward. We're going to try and put this material into written form. I'll explain later how that's going to take place. And we will be sending out certificates to the winning lawyers and everybody else who was involved in this particular matter. Stephen, I want to thank you. Listeners, I want to thank you. I want to wish everybody an amazing holiday season. Thank you for being part of our case of the year. Stephen, any parting words to us?
It was a blast as always, and apologies for our long-windedness, especially my own, but there were so many great cases, and I hope people enjoyed it and learned something. I had a great time. Thank you.
Margaret, I can tell you that the bow tie is a regular feature from now on. Cases of the year, bow ties coming on. I'm going to get a new bow tie for next year. This is the time, Stephen. Thank you, everybody, and have, as always, a very great day. Hey everyone, thanks for watching Top Cases of 2024 with myself and Professor Stephen Penney. This year we're trying something a little different. In addition to this awesome award show, we're putting together a written version of Top Cases of 2024. This is going to come out in ebook form, though we'll of course consider printing it if enough people are interested in having a printed copy. It's going to address every one of the cases we consider in this award show. It'll point out who all the winners are, and it'll provide all the cutting-edge analysis and commentary that you expect from Criminal Defense Essentials. So keep an eye out for this exciting new product that's going to be available. I can tell you right now that our CD subscribers are going to get access to this ebook for a substantially discounted price because we want to reward everybody who was a part of the show and enjoyed it so much. Keep an eye out in early 2025 and we'll be sending you a way to get your hands on the top cases of 2024 in written form. Hope that's of interest to you. Have a great holiday season, everyone.